let's talk about living trust. It's about why you should have a living trust. In fact, I've made several videos on this topic, and it's been about 3 years since I made my first video on living trust. I thought it would be good to organize the information again, so I prepared this. As I always do, I intend to give you the conclusion first if possible. You absolutely must have a living trust. If you have assets in the United States, you absolutely must have one. To give you some background as an introduction, many of you have probably heard about living trusts. And I also think that among those watching this video, there are more people who have heard of living trusts but haven't actually created one yet. This might be a very typical reason. It could be a situation like watching today's video, or you might attend a session where they explain that you need a living trust and you think, I should do it. But you hear so much information at once, like, does it reduce taxes? Does it also have asset protection functions? No, it's not. Then what about the trustee? The concept of a successor trustee comes up and you wonder how the inheritance process continues. You think, this is too complicated, I'll do it later, and you put it off, only to encounter a similar situation. A year later, you attend a seminar or go through a similar process and start having the same concerns again, and this endless cycle seems quite typical. So, today I hope that, by watching this, you understand that if you have any assets in the United States, a living trust is something you absolutely must have. So let's dive in. I'll try to explain the basics of a trust. This might be the most difficult part. What is a trust? In our language, it means trust or fiduciary. This definition is actually the most difficult. Let me give it a try. A trust is a single contract or legal document. The content of this document is created by a person called the grantor. The grantor, or the founder, creates the trust document, and according to the contents of this document, the trustee manages the assets entrusted by the founder. The profits generated from this management can be taken by the beneficiary. This series of private agreements is called a trust. So let's compare this with establishing a corporation. You know, when we talk about running a company, if we set up a company and conduct business through it, I am a shareholder. As a shareholder, I establish the company and invest capital into it. And although I might run it directly, under corporate law, I am not operating as a shareholder, but as a director, officer, or employee managing the company. And based on that management, they earn money, take their salaries, and any remaining profits are returned to me, the shareholder. This is generally how a company operates. Here, the shareholder or the company can be replaced by a trust. The shareholder, who is likely the founder, can be seen as the grantor. The general manager, like the director or officer we mentioned earlier, can be seen as the trustee. In a corporation, the founder and the stakeholder or shareholder who receives the benefits are generally the same person. However, in a trust, this is not necessarily the case. If the grantor is the founder, the ultimate benefits are received by the beneficiary, which presents some differences. Nonetheless, in the broader framework, it can still be compared to corporate operations. This is what a trust is. So, let's talk about the benefits of a trust. What I emphasize the most is this. You don't need anything else. Just 99% of the utility is in allowing you to avoid probate. It would be to avoid probate. Then, what is probate? It is the process of validating a will. This is a very painful and lengthy process. Let's consider inheriting real estate, for example. Mr. Hong Gildong has passed away. Then his son needs to transfer the real estate to his own name. In the case of real estate, usually in the United States, in each county, deeds are recorded. It's similar to having a real estate registry recorded. Let's say you go to the county and say, my father has passed away, so please transfer the ownership on the record to me. Then the county clerk or officer will. They will ask, did you bring a court certificate or court order? And you'll wonder, what is that, really? When they tell you to go get it, that's when probate begins. Probate is the process where the court intervenes to make a final decision during the transfer of assets. Just hearing about it, right? Takes a long time. It's complicated because it's a court procedure. Also, you have to hire a lawyer or an estate representative, which costs a lot. Generally, it is said that probate costs range from 3 to 5% of the estate's assets. And during that period, the assets are frozen, so you can't use them as you wish. And since it's a court procedure, it won't be a private process, but a public one. Simply put, you just don't want to deal with the hassle of a probate wedding. You don't want to handle it. By creating a trust, if you just nominally transfer the ownership of your assets to the trust, this whole process disappears. So, just for this reason alone, there is more than enough reason to create one. And when it comes to creating it, of course, I'll elaborate on this later, but they say that in the worst case, it's better to create one yourself than not to create one at all. Of course, I don't recommend creating it yourself. Now, there are other benefits such as flexibility and control. This means it's just like owning it yourself. Although there is a nominal ownership transferred to a trust, which is not personally owned by me, it is flexible when it comes to utilizing this asset. In terms of control, I can utilize it 100%, as if it were my own. I can enjoy it. It means I can control it. For example, I can buy and sell assets, add or remove them, or even dissolve the trust, all in the way I want. And another thing is, once a trust is properly established, although it is recommended to review it, every few years it can be created as a document that doesn't need to be changed often. Additionally, depending on how you name the trust, since the ownership is under the trust name and not your personal ownership, privacy can also be secured. What is known as incapacitated planning, even if I haven't passed away, by specifying the contents in the trust documents. There is the advantage of being able to include instructions on how to manage the assets in case I become, for example, comatose, have an accident, or suffer from dementia and cannot make normal judgments. In a way, this ultimately means it can replace a will. The advantage over a will is that it can avoid probate and the actual distribution. The process of inheritance can be carried out much more quickly, which is an advantage. The most important thing is that it allows you to avoid probate. So then, who should create this? You might already know the answer. The answer is everyone. If you have any assets in the United States, everyone should create one. Shall we take a closer look? Shall we think about homeowners, own property, real estate? Of course, I should create a trust, just like in the case of Mr. Hong Gildong earlier. Have children. So, I have children whom I want to inherit my assets, especially if those children are minors. The benefits provided by a trust compared to not having one would be obvious. And shall we think about business owners? A business. I would be very concerned about the continuity of my business, and I would want to secure it. A trust would provide a foundation to ensure that the business can continue even if something unexpected happens, because you can avoid probate. And there are other such cases, of course. So then, when should this be set up? It's probably about when to set up the trust. You probably already know the answer to this. Is it too easy? If you don't have any applicable assets, it wouldn't be necessary, but generally, depending on the state, assets valued over $100,000 to $150,000 are subject to probate. Therefore, if you have even one asset valued above that, I recommend setting up a trust. Then sometimes people ask this question. They say, my assets are in banks and financial institutions, and I've heard that even without creating a trust, I can designate a beneficiary, so that when I pass away, these can be transferred to my desired beneficiary without probate. That is also correct. This is called the TOD feature. It's called transfer. So by designating a beneficiary, or the same goes for a joint account, it refers to the feature or characteristic of financial products that automatically transfer to the beneficiary after one's death. Nevertheless, I still recommend creating a trust, because this is an extension of what I mentioned earlier. It might sound a bit funny to say this, but if I just pass away, the problem is simpler. But you can imagine cases where that's not the situation. If I have an accident or develop dementia, or in any case, this is referred to as being mentally incapacitated. In this case, financial assets with TOD transfer on death features are helpless. Because if I'm not dead, I haven't granted anyone else the authority to utilize these assets. Therefore, to address this as well, you need to designate an agent, often referred to as a power of attorney, who can make financial decisions on your behalf. That's why people say it's better to create a trust. So, considering those factors, the TOD function might be okay. But I think a trust is better. The next question would be about how to establish a trust. There will be two perspectives on this question. One is, can I do this myself? Or do I absolutely need to hire a lawyer? That's the first question. The second is, in what order should this be done? It seems the first question is likely more significant. Whether you should create it yourself or have a lawyer do it, I would certainly recommend having a lawyer do it, because it's an extremely important document. And another thing is, while I'm trying to explain in plain terms today, when you delve into specific clauses, there will definitely be complex content. Of course, these are not things you, as users, necessarily need to know. Nevertheless, they are important. For example, when we create a trust for a couple, generally we tend to think that gifts and inheritances between spouses are not subject to gift or inheritance taxes without any limits, but such a rule is a benefit only available when the recipient spouse is a U.S. citizen. However, in a trust, by including specific provisions, even if the recipient spouse is not a U.S. citizen, they can enjoy the same nature and level of benefits. In other words, an unlimited exemption, a gift, that applies. The unlimited gift tax exemption. You can include such provisions to make this possible. But when you create this in a DIY manner, it's easy to overlook these aspects. There could also be provisions on how to interpret the trust when the location of certain assets or your residence changes, or when the criteria for estate tax or estate tax exemption increase or decrease. There are functions to ensure that the assets of the trust are not affected. To include these specifics and avoid missing important provisions, professional assistance is necessary. The second question is about the order in which this is done. You create the trust documents, select the trustee. Sometimes it should be reviewed every few years, and these are some of the things to consider. However, as I mentioned earlier, if done correctly, you can create a trust that doesn't need to be altered in any situation. So with that, we have wrapped everything up. Sometimes people are curious about the additional benefits of a trust, and this might be a misunderstanding about trusts. So to address that, let's go over the types of trusts. From this point on, it can be considered somewhat intermediate. It's okay if you don't know this. Now, the types of trusts. Up until now, we've been talking about living trusts, but to be precise, it should be types of trusts. When looking at the types of trusts, they are divided into two categories. They are called revocable trust and irrevocable trust. In other words, it's about whether it can be revoked or not. And now, as I prepare several videos, I explain trusts with various functions. For example, I talk about trusts for asset protection, asset purpose trusts, tax-saving trusts, and Medicaid trusts. These are not the revocable trusts or living trusts we've talked about so far, but rather they are considered irrevocable trusts. Shall we go into more detail? So, what we call a living trust or a revocable trust is something I keep recommending that everyone should create. This is a simple trust by nature. It's a light trust. It's a fundamental, foundational trust. And the purpose of this is, as I mentioned earlier, 99% of the trick is to avoid probate. It solves that issue. And besides that, who holds the ownership of the assets? It remains with you personally. That's why it's easy, light, and fundamental. It's not a difficult decision nor a heavy one. And that's why the benefit provided is solely avoiding probate. There are no other benefits, as I mentioned. In contrast, irrevocable trusts are heavy trusts, and they are advanced, complex trusts. And the purpose of establishing these is, of course, to provide protection from probate. It allows you to avoid probate. There are additional benefits beyond that. As I mentioned earlier, there are things like asset protection, tax savings, or achieving stronger privacy, or the purpose of the assets, and so on. And practically, the background that makes these benefits possible is that a trust is an irrevocable separate legal entity, which creates the condition of transferring ownership of my assets to the trust. Once again, a living trust is necessary for everyone, while other trusts like irrevocable trusts are case by case. It depends on the individual whether they need it or not. Now, this will probably be the last part. Let's revisit some misconceptions about trusts. First, is a living trust only for wealthy people? That's not true. Second, does creating a trust mean losing control over my assets? We said that's not true. I mentioned that you can still maintain the same level of control. Third, does a living trust allow you to avoid estate taxes? I said no, it's unrelated to taxes. To enjoy benefits regarding estate taxes and gift taxes, you need an advanced trust. I mentioned that you need to set up an irrevocable trust. The fourth misconception is setting up a living trust is too complicated and expensive. No, it's not. I mentioned that it's a light decision that doesn't incur such high cost. The fifth one is, can a living trust also provide asset protection? No, the revocable trust we are talking about has nothing to do with asset protection. Next, can a living trust help reduce income taxes? I mentioned that it cannot. In conclusion, you must definitely set up a living trust. This is really simple and straightforward. Nothing special. But for some reason, the person explaining it mixes in legal jargon as if there's something significant, or they confuse it with some other advanced type of trust, making it seem complicated. I think that's why people find it difficult. Coming back to it, a living trust is nothing like that, and the cost effectiveness is tremendous. And finally, in managing this living trust, it can be done in this way. The living trust can be at the top, overseeing all of your various business activities, allowing for such a structured setup. This, of course, would apply to those with substantial assets. If you have a lot of assets, it leads to this kind of structured setup. Whether you have many assets or not, a living trust is something that anyone living in the US with assets in the country must have. As the first step in estate planning, I emphasize this once again.